Hello and welcome viewers. You're watching this special presentation of Sansad TV with your host Kriti Mishra. As Bharat celebrates Samvidhan Divas, Sansad TV brings to you this super exclusive interview of highest law officer of the country, the Attorney General of India, Mr. R Venkataramani.
Article 76 of the Indian Constitution deals with the position of Attorney General of India. He or she is the highest law officer of India. As the Chief Legal Advisor to the Government of India, the Attorney General advises the Union Government on all legal matters. He or she is the primary lawyer representing Union Government in the Supreme Court of India. The Attorney General is appointed by the President of India on the advice of the Union Cabinet. Senior Advocate R Venkataramani was appointed as India's 16th Attorney General on 28 September 2022. He took office on 1st October 2022, succeeding the incumbent AG KK Venugopal. Venkataramani was born on 13th of April 1950 in Puducherry. He studied at the Government Law College, Puducherry, and started practice with the Bar Council of Tamil Nadu in 1977. He moved to Delhi to practice in the Supreme Court in 1979 and was designated as a senior advocate by the Supreme Court in 1997. Venkataramani has specialized in the law of indirect taxes, constitutional law, human rights law, and civil and criminal law. He represented the centre in several state governments, universities, and public sector undertakings in major litigations before the Supreme Court of India and the state high courts. He was appointed as a member of the Law Commission of India in 2010 and again for another term in 2013. Venkataramani has completed more than 42 years of practice in the Supreme Court of India.
Sir, welcome to Sansad TV and thank you so much for joining us.
My pleasure.
Sir, Constitution of India is the supreme law of land, a distinctive document with many extraordinary features, the longest written constitution of any sovereign nation in the world. Sir, what are the unique and distinctive features of our constitution?
One, firstly, the constitution belongs to the people of India. The preamble states that we, the people of India, got this constitution enacted for us. It is not symbolic, it was real. And secondly, every 5 years when people elect governments after governments, we see the vibrancy of people's faith not only in democracy and but most fundamentally that the constitution has given us the opportunity of building a nation. Therefore, it's a people's constitution. At the same time, it's a very strong and vibrant constitution, as the people of India are strong and vibrant.
Absolutely, sir. And the, of course, opening lines of the preamble to constitution says that we, the people of India, adopt, enact and give to ourselves this constitution. Ultimately, the power rests in the hands of the people. So there's a lot of discussion on the basic structure of constitution. How does the Attorney General of India interpret the basic structure of constitution?
We built a house for ourselves. Foundation, right? After the foundation, we erect a lot of superstructure. As long as the foundation is strong, the superstructures are equally strong. When you talk about basic structure, we're talking about the architecture of the constitution. If you compare various constitutions of the world, I find the architecture of the Indian constitution stands a little away from many other constitutions of the world, either before World War II or post World War II. So we paid a lot of attention to the details of the constitution and to build into the distribution of power, legislative, administrative, executive, fundamental rights, directive principles, all that woven into a beautiful architecture. So if you pick up any one of them, right, the fundamental rights, the constitution falls down. The power of the courts to say what the law is, the constitution falls down. The legislative power and the power of the courts, the balance, the constitution falls down. So there are many examples in the neighboring countries and certain Asian countries where the balance, because of the absence of an architecture, the balance was never there. So we talk of the basic structure as the most informing principle of the constitution.
Absolutely, sir. And since you mentioned about other countries, In contrast to many nations that gained independence at the same time as India, India's constitution has stood the test of time. What are the inherent strengths of Indian constitution?
Two important features. One, that the rights of the people enshrined as inalienable and non-negotiable, and the strength given to the people to access these rights through an approach to the superior courts of India. So they go as a corpus of a principle of jurisprudence that, and secondly, the ability of legislatures and the executive to have experiments with political, social and economic measures, tools and ideas. So the courts also facilitate and enable that, but the courts also watch, keep watch on what the legislatures do, sometimes wrongly, sometimes rightly. So therefore, these two important aspects of the constitution being flexible on the one hand as regards the governance ability to experiment. On the other hand, fundamental rights is non-negotiable, inalienable, non-violable, all that, the exquisite balance with which both government, courts and citizens have played with this, is very, very unique. And you have a 300-year experience with the United States Constitution, but you will find even today they are struggling with some fundamental questions, despite a long line of jurisprudence by the Supreme Court of the United States. So, but within a very short span of 50 to 60 years, I think we have built a very, what I call strong foundations for the Constitution working. A lot of dissents, critical voices, of course, are bound to be there, but I find them matters which probably fall into the periphery, not at the substance and the inner essence of the Constitution. The inner essence of the Constitution today has become part of the psyche of the Indian people. So once I was traveling from Long Island to the New York airport, the cab driver picked up a conversation with me, and he said when he found that I was a counsel practicing Supreme Court of India, he began talking about an important judgment of the US Supreme Court on racial segregation. I was so surprised that a cab driver who looked so ordinary could have such an knowledge about the constitutional law of the country. I always thought that people, let's say an auto driver in our country, would be able to engage me in the conversation. The way they engage in a conversation today is by making their presence in the elections. That's the way they make their presence in the working of the Constitution.
How do you see and perceive the complementarity between fundamental rights and fundamental duties?
I don't think there is any dichotomy. There is a lot of discussion almost in every part of the world today. You take again the United States, people began to talk about an ordered liberty. If liberty is not ordered, essentially it's an echo of the balance of the marriage between rights and duties. So in our own ancient knowledge system, we always thought a right without a duty and vice versa doesn't exist. So that's why you talk about dharma of justice. The word dharma, of course, whichever way you define it, it goes to the essence of it that am I doing something which is right by way of my word, by way of my thoughts or my conduct? So word, thought and conduct, everything must be on a balance so that I don't hurt another person. So while that is the essence of an Indian thought process, in practice it must not have failed. But this essence of the Indian thought process, I think, continues to inform this. So even in the absence of fundamental duties, I think we would always talk about rights within restrictions. The restrictions means duties, not necessarily a state-enforced restriction. But why would somebody, a government wanted to regulate social media, right? Social media is a new avatar of the freedom of expression of people. So if state has to regulate it, then it essentially finds that the regulation is not for the pleasure of the state, it's for the needs of the people. The needs of the people, therefore, will have to be balanced. And who will do that? If as a social media participant, I don't see the responsibility of my not going beyond a limit, then somebody will have to come and say, probably you are crossing certain limits. Therefore, knowing limits, understanding limits, practicing limits must be part of a right. And I think it's a cultural transition. And it's easy for a corporate group to say, my freedom of expression is curtailed because the government regulates for something like a paper availability, newsprint availability, or government says I'm going to censor. That's a part of a section of the people. There the rights may not necessarily engage a duty aspect. Social media is different. So when you talk about, again, profiting beyond a limit, so Arthashastra talks about it, Chanakya talked about it. So we have all those principles built into our understanding of what is dharma. So I think in the past 60, 70 years, while on the one hand, certain fundamental rights have been read very expansively, and they are also required to be read. Not because you will not read duties into them, like a right to privacy. So they become important to again balance some countervailing assertions in the community. So that's how I look at it. I find ultimately there is no dichotomy. Every right will have to be read as part of a duty inbuilt into it. And you pick up Article 51A, you can probably find in some fundamental right or the other, it's a matching point.
Absolutely, sir. So there are two sides of the same coin. You also talked about organs of the government, the executive, judiciary and legislature. Sir, how do you see the demarcation of responsibilities, rights and powers of these organs in Constitution?
See, we began with a certain understanding of the working of the executive. We thought the executive will by and large abide by parliamentary wisdom, and there will be a harmony between parliamentary wisdom and the executive responsibilities. But sooner we realized that in the field of economic transition and eliminating poverty and other socially aggravating factors such as caste and inequality, sometimes Parliament may have to do a job which executive may have to push. Sometimes executives may have to be a little more vibrant. Therefore, we see a balance which can never be drawn in any straitjacket formula. And then much later, when you found that we had to move away from a state-regulated economy, globalization, international trade and commerce, and then sooner with the technology innovation, and virtually invading our homes, our minds, and whole space of a citizens' affairs. So I think Parliament and executive will have to play a creative role where one understands the other. I don't think any examples from English Parliament or English executive will give us any answer. And on the one hand, we also have other global issues. So India, of course, certainly doesn't aspire to be a hegemonical power in the world. While we talk about economic power, we are not talking in the sense in America or some other country would have had it, before Second World War, or some other country would like to, be a major power in the world. So to be a major economic activity is different from dominating the rest of the world. And in all this, how do you really formulate policies? How do you draw lines? How do you understand the role of India domestically and internationally? These are very, very difficult questions. But I think it's important that the Constitution has not drawn any rigid line between Parliament and the executive. It is a happy marriage which must always happen.
Perfect, sir. It's a happy marriage, and of course, India does not talk about hegemony. It has always spoken about one earth, one family and one future. But sir, very important point and feature of the Constitution, of course, the amendments, the interpretation. So as of September 2023, there are around 106 amendments to the Constitution. How do you see these amendments and how have they shaped the destiny of our nation?
Our Indian Constitution is always compared to the US Constitution, a few other constitutions which are very simple, right, and not very lengthy. But within the first few decades of the American Constitution, they had more than 25 amendments, right? But then it was a different experiment. You go back to the year 1800. So America was different. So they had a lot of time before they were caught on by global expansion, global invasions in science, technology, and so on and so forth. But we entered our democratic experiment much later, and therefore the unamendability of a constitution is another problem. Again, I cited about the neighborhood examples. So as unamendable a constitution is, then the frictions in the working of the constitution, then the desire or the inclination of an executive to undo the constitution will become very visible. So therefore, whether it is 106 or 110, I don't think the count matters. What matters is, why did the Parliament and the executive venture to amend the constitution in certain fundamental aspects? Was it because the Parliament was wrong? Was it because the executive was wrong? Were they pushing agendas which are unconstitutional? Or they wanted to still find out some elbow within the constitution to do what they wanted to do? I would put it belonged to the later dimension. Every government wanted to have an elbow to do what they thought would be a better way of pushing certain political and social agendas. So social justice is very difficult to define. So as we go, so we had seen all those amendments to Article 16, where the reservation principle was constantly under challenge. So, or the government executive wanted to bring the property rights, debate beyond courts, scrutiny. For somebody to say it is wrong, well, good. But then, this is how social dynamics of aligning entrenched rights and looking forward to new dimensions of rights and creating new rights, etc. You can't have what called a textbook formula for doing all that.
Absolutely, there cannot be a textbook formula, sir. And of course, it was because of the sagacity, prudence and foresight of our founding fathers that we have such a dynamic and living document. Sir, how has that vision of our founding fathers translated into action, and particularly in New India, because you were talking about our economic prowess?
I would probably be happy to give you a lot of statistics if I had them readily on my hand. But let me put it very generally. If you look at the level of literacy in 1947, 1950 and what it obtains today, if you look at the number of educational institutions in 1950, whether it's primary schools or much later in 1990s, we were all getting into university education, we were struggling to find a place in the very scarce number of higher educational institutions. But you look at the enormous growth and virtually, so on the literacy front, on the education, access to education front, we have covered enormous amount of field. The question is not whether it is qualitative. Firstly, quantity first comes. As quantity competes, quality will necessarily get in. So also, if you look at the infant mortality or access to health, India has done remarkably well. But the problem is, look at the range, the vastness of people, the country, the areas, and probably somewhere where we have not paid enough attention is important legislations on access to health, education, or maximizing employment, etc. So the way they are enforced, the accountability in enforcement, principles for accountability to be built in within the legislative framework, and then how accountability can be secured through a cost-effective, enforcement supervision. All that probably was lacking in our legislative framework. So perhaps it's time for us to relook at our legislative frameworks and bring accountability as a self-enforcing process within each law, whether it is a Bonded Labour Abolition Act or a Securities Act, Regulation Act, or any one of the legislations we are talking about, economic advancement, economic equality, or even in a context of equal opportunities for men and women. All those legislations, I think it's time we look at the legislative framework to build in an accountability principle.
But sir, how do we do that? How do we bring in the element of greater accountability?
Yes. So let's look at it from a point of view of what are the institutions available for doing that? We have a public service, right? A public service is geared to act as a neutral and altruistic individuals. Does it really happen? So whether you look at the police force or look at, for instance, the transport department, so you can pick up many of those departments where public interface with public services happens. And so therefore, I think Delhi government is trying to bring in a law. So I'm looking at whether the responsibility quotient of public servants can be rethought in terms of accountability, which can be periodically supervised. We have the confidential reports, which will you look at from a distance. So I am not very clear how it can be effectively drawn, but I am very clear about it needs to be drawn. But probably as more thought goes into it, we can work out the principles. I think it's important for us to do that.
Well, absolutely, sir. There are more deliberations that are required. But, sir, we're talking about India at 2047, dreaming to be a developed nation. We're talking about Amrit Kal. Going ahead, the importance of Constitution in making India a developed nation.
Constitution is not a mere paper document. For centuries, different countries have lived without this ink on paper called a constitution. But then they lived without what we call today from a post-human rights understanding, societies without rights. I don't know whether it's right or wrong. Without going into that kind of a analysis, if constitution is not a mere paper, it is like looking at the health of my home. How do I keep my home healthy? It's not merely sweeping, right? I look at it each and every corner, cobwebs around. So I try to look at every part of my home and see that those undesirable elements which may take away the beauty, the aesthetics, the functioning, the working of a home are not there. So that is the culture of a constitution. So citizens' participation, I think, also needs a little more closer attention. I also think that citizens' participation in elections will not be the end of representative democracy. So our ability to participate in the lawmaking process also needs a very close attention. So how often and how close citizens can command the making of a law or the remaking of a law or the alteration of a law, through what process? I don't know whether a mere presence of a representative in the parliament or legislature is good enough in that sense. So we don't really have a neutral, accessible mechanism or a process where citizens can command legislative assemblies to listen to them. I think we need to make that very important institutional arrangements. The example is, you have the petitions committee of parliament.
That's right.
Every legislative assembly has some committees, but I think their functioning is very minimal. Functioning therefore should be made more broad-based, and to act as a channel or a medium to communicate to parliament as to how citizens' views on certain matters should be structured and received in a structured way. It's okay that opposition parties with their own views or citizens groups may have their own criticisms of a law or a lack of a law, but that, I think, is only one part of the story. So why should we not conceive of greater structured institutional participation of people in the lawmaking process?
Absolutely, sir. That's a very, very valid point. And sir, of course, we've been saying that youth are going to be the catalyst of change. So before we wrap up this conversation, your message to the youth of the nation.
India's constitutional fundamentals are strong. India's faith in democracy is absolutely beyond negotiation. And the youth of the country, there is no reason why we should feel cynical about the future of our country. One important issue which every one of us must keep talking about in our minds is one. All of us value freedom. All of us want to talk about liberty. And why do we value that? Because the more I am free, the more I have my liberty secured, I feel I am able to live a full life. So the fulfillment of life comes when nobody tells you what you should do about the affairs of your life, subject to, of course, just way conduct, etc. On the other hand, if you don't have that, and you say, I'll have a complete unbridled freedom, then who cares for my neighbor? Who cares for those deprived sections of the community where justice must be made available at any cost? So the balancing between justice being made available. When I say justice, it's not merely going to court. I'm talking in the larger sense, social, economic, and political justice. The ability to live a full life. So, in the absence of a state or a government, it cannot happen on its own. Therefore, we have all those debates on free markets, deficiencies. So, if you go to US, France, leading economic thinkers say, we have to rethinking on socialism. Is there a failure of the market economy? These are contemporary thoughts which I think are occurring all over the world. But I don't think that needs to bother us. It's bound to happen because we are still experimenting with those little holes or gaps which can be filled up by creative understanding of what the state can do, what people together can do. So, I am sure India can do that.
Well, absolutely, sir. On that very positive and meaningful note, thank you so much for joining us
My
on
pleasure
Sansad
again.
Television. Pleasure speaking to you, sir. Well, viewers, that's all we had for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.